Welcome to Michigan Condo Voices, where real co-owners and real Michigan communities come together. We break down the issues that matter most with clarity and transparency. Let's get into today's episode.
Hi everyone, I'm Stephanie and welcome back to Michigan Condo Voices. Please like this video and subscribe to the channel so other co-owners can see it. This is a short educational video for co-owners about how to read board legal updates carefully, especially during times when litigation, complaints, or legal proceedings are involved. Board updates often sound official, final, or reassuring, and sometimes they are accurate but still incomplete. Today's goal isn't to dispute anything or assign blame. It's to help co-owners better understand how legal communication works and how to stay grounded when reading it. This channel focuses on education, transparency, and governance processes, not conflict. Legal updates are usually written by attorneys or reviewed by attorneys at a minimum. That means they tend to use formal language, emphasize what did happen, and minimize what has not yet happened. This doesn't automatically mean anyone is lying or acting improperly, but it does mean that legal updates are often selective by design. They are not full case summaries, they are not neutral timelines, and they are rarely written with co owner understanding as the primary goal. Here are a few phrases co owners may see and how to interpret them thoughtfully. The motion was denied. This usually refers to a specific request at a specific stage, not the entire case. The court did not grant the request. This does not necessarily mean the issue can't be revisited later, and that's very important. The court found the allegations to be false. Early motions are often decided on procedure, not full evidence review. And the next step is mediation. Mediation or facilitation is common and does not imply guilt, innocence, or final resolution. These statements can all be factually accurate while still leaving out important context. Communications may not explain what stage of the legal process the case is in, whether discovery has occurred, whether issues can be raised again later, what decisions for procedural versus substantive, and what authority the court has not yet exercised. That's why it's important for co-owners to avoid reading legal updates as final conclusions, especially early in a case. When reading board legal updates, it can be helpful for co-owners to ask reflective questions, not assign blame, but to understand the decision path. For example, were there opportunities earlier in the process for dialogue or facilitated resolution before litigation became the primary path? When you read a legal update, consider asking yourself thoughtful questions, such as what exactly was decided and what wasn't? Was this about process or outcomes? Is there missing context that would change how this feels? And am I reacting emotionally or understanding procedurally? You don't need to challenge boards. You don't need to speculate. You simply need to stay informed without assuming the story is complete. Reading legal updates carefully help co-owners stay grounded, especially in communities where communication feels overwhelming or one-sided. Understanding processes doesn't escalate conflict. It protects clarity, patience, and trust. And informed co-owners are better positioned to engage thoughtfully no matter what happens next. Thank you for listening. Please like, comment, share, and subscribe to the channel. Take care now.